And from there, from the alibi and and Cy-Ray, they go into the advanced timing records, which, if you look at the thumbnail, I put Judge Hippler in some shades, because man, I could have swore he was DT up there. You know what I mean? Yeah, based on what he was saying, I think he saw what I was trying to say. But listen for yourself.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue and doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was a carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way.
That's the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
the 7 days that he's back home?
Maybe.
I'll ask the state about those. If they receive those, I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did. And I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant,
you would agree there's no evidence that AT&T provided those or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
an officer of the court.
As an officer of the court, I would like to ask Nick Balance that. And here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence. And yet you've provided no factual basis, zero, that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where's the evidence that Mr. Kohberger?
I think in that moment, it just clicked. That was the moment that it clicked for Ann Taylor. I think right now when he just said, but they didn't have him until December 19th. I think it just clicked in her head. Oh, snap. You know, we've been arguing this entire time. 20 different compelling, discovery motions that we've seen about Bryan Kohberger's, AT&T records and all this other stuff. We've seen defense, was it like 20th motion for compel this, that, and this entire time she didn't understand it. And she had Cy-Ray supposedly 15 years experience with AT&T. He didn't know about the 7 days. It sounds like his experience is about to be as far as about to be as worth about the amount of jobs he's going to get after this. I don't see this man ever testifying in court after this. This is not just embarrassing. This is career ending.
Timing advance records from AT&T were available to anybody in December without a prior request that they save those.
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until I think about December 19th.
Right.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without any evidence at trial.
Your Honor, we have litigated.
He just called Cy Ray's affidavit a conspiracy theory. If you guys think that he's not going to call his other stuff junk science, you're off this planet too. Because I think that's what we're going to find out next. Conspiracy theory connects. Next thing is going to be what? Junk science. Those usually go hand in hand together. Hand in hand together. I mean, you can't get anybody called it a conspiracy theory.
Did this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information.
You see, here's the thing. It's not. I mean, it is new information, so to speak, but they filed Cy Ray's affidavit after the state presented their information that they only had 7 days. And they also presented a certificate from a COA, a certificate of authenticity from AT&T, Stephen Gordon, stating that AT&T only held them for 7 days. It's not anybody else's fault that you don't know or you didn't read it right. I mean, you're going to go, a little bit later, we're going to find out that she wants the state to do her job for her. She's going to say that, they're going to stall and they want more time because there's so much evidence. There's 56 terabytes, et cetera, et cetera, et cetera. And that this could take 100 years to go through. And it's just all a stall period. And the fact is she didn't understand it. She didn't understand the affidavit. She was quick to pull the trigger. She probably had Cy Ray write it well in advance. These folks were anticipating things. Remember, in Cy Ray's document, he said, "Oh, I anticipate that Stephen Gordon is going to say this and that," and they were just so wrong. Their anticipation of what they were trying to, that they thought that the state was going to go do, was wrong. The anticipation should have been the 7 days. He should have known. Cy Ray, being working with AT&T for 15 years, he should have known this. But regardless of that, it's finally dawning on her, on Ann Taylor, and it's clicking right now. Oh, they didn't have it. And she goes on to say, it was like, well, we've made so many motions on this. Well, you've spent so much time and wasted so much time, and you didn't understand it. And at the end of the day, you're going to try to say that there's just so much discovery that you can't go forward at this time. And it's just a bunch of bull crap at the end of the day.
To me now, but the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December?
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention more
Motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that And you,
I understand your confusion and concern previously. What I don't understand it is now.
Exactly. She's like, oh, well, let's pretend that we didn't know that. They should give it to us. What? Oh my! I couldn't even believe that was an argument. I couldn't even believe this is an argument. Can you imagine? Like that's what her argument is. Let's imagine that you didn't know that. Can you imagine how we felt? I can't believe she said that in court. I am dumbfounded that the fact that she literally said that in court. You know, I'm gonna rewind this just a tad bit. I have to. Just a little bit. I gotta re-listen to what she just said.
advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you,
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
he is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that.
Shit, if I was Cyree, I'd be like, no, don't you call me up there. Oh my God, she wants to throw him on the stand now. So what? So that he can say what? Can you imagine if we didn't know the 7 days didn't exist? We would be pretty pissed. I mean, there's a lot of what ifs that can happen. You know, what if my brother was born different? He'd be my sister. You know what I'm saying? I mean, we can what if all day. This is an actual hearing. 4 people's lives were taken, and you want to play imagination games? Get the heck out of here.
Evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe that that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days, and he had supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got him in a way that they weren't supposed to at that time, for all I know. He didn't name names, he didn't identify it, he didn't put it into any context. The state had indicated and that provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all.
Oh man, this was it was wildly entertaining, to be honest with you. You know, I was just dumbfounded by the fact that, you know, she wanted to play this imagination game to try to make, I guess, I mean, at the end of the day, she could have just taken accountability, right? She could have just said, hey, we didn't know about the 7 days. That's why we presented this argument. We know now that there's a 7-day period and that Bryan Kohberger wasn't a suspect within that scope of that time frame. And so we're going to withdraw the motions to compel. But no, they're like, you know what? We'll bring Cyree on. What the hell is he going to say? What is he going to say? Oh, well, you know, in August of 2021, the FBI showed me something that they shouldn't have. What does that have to do with Bryan Kohberger? And what does that have to do with the FBI getting in contact with him or any of those type of things? It's just craziness, guys. Just craziness.